Well, let me ask you this then. Does the mistrial
No.
return us to the exact position, not us, does it return the case to the exact position that it occupied before the trial?
If it was an offense in which was commenced properly and within the statute of limitations, yes, mistrial would put us back like it was before. However, he was acquitted of all the ones in which the statute of limitations had not possibly expired.
So the jury never had
They never had the right. And you had the right to not even give the instruction. And if you gave the instruction, it cannot be acted upon because it's a nullity or void. And unless the defendant waives it. And that's what some of the later decisions talk about, what that constitutes. And it has to be a knowing and voluntary waiver.
Welcome back to Fair and Square Files, everybody. Thank you so much for returning. Today, we dive into the riveting and controversial case of David Swift, the man accused of the 2011 murder of his wife, Karen Swift. After more than a decade, the legal battle continues to unfold in ways that no one really could have anticipated. Now, to give you a little bit of case background if you're not familiar with it at all, David was indicted in 2022, 11 years after Karen's disappearance. Karen, aged 44, was reported missing on October the 30th, 2011, 3 weeks after she had filed for divorce from David. The mother of four had attended a Halloween party earlier that evening. Now, according to David, she left the party early to pick up their daughter from a slumber party. Karen's SUV with a shredded tire was found near her home, and inside the vehicle were her purse and a Halloween mask. Prosecutors claimed that David was the last person to see Karen alive when she returned from the party. 6 weeks later, on December the 10th, her body was discovered by hunters in an abandoned cemetery. Oh, sounds like a horror movie, doesn't it? The autopsy report indicated that Karen died from blunt force injury of the head. Very, very suspicious. Now, by the time of his arrest, many years later, in 2022, David had remarried and moved to Birmingham, Alabama. He also faces separate charges in Alabama for stalking his second wife, who has since divorced him. So make of that what you will. Last month, a jury was hung on charges that David killed Karen, finding him not guilty of murder and attempted murder. However, they all seem to stumble on the voluntary manslaughter charge. Listen to the judge as he reads the verdict.
The court will enter a verdict of not guilty as to the charge of first-degree murder. The court will enter the charge of not guilty as to attempted first-degree premeditated murder. The court will also enter a not guilty verdict with respect to second-degree murder. And the court will also enter a not guilty verdict with respect to attempted second-degree murder. The court will enter and declare mistrial with respect to the charge of voluntary manslaughter.
And that's the charge that David's attorneys say that exceeded the statute of limitations. David, now 56, was expected to be retried on the voluntary manslaughter charge but not the murder charges. It is important to note that there is no statute of limitations in first and second degree murder, but under Tennessee law, voluntary manslaughter carries a statute of limitations. David Swift's legal team argues that the statute of limitations for voluntary manslaughter has expired, making the charges invalid. And that is a dramatic turn of events. What was meant to be a bond reduction hearing became a motion to dismiss the charges altogether. Let's take a listen to Daniel J. Taylor, the defense attorney for David Swift, as he discusses the issue with the judge. He also highlights past cases where the same rules applied. Now, just very quickly before we launch straight into that clip, if you haven't already, if you could hit that big red subscribe button, that would be amazing. And exciting news, our membership program's up and running, so if you want to be part of that, welcome to the family. It's also such a fantastic way to support the channel. Right, let's check out this next clip.
It says here, it's essential elemental principle of law that an accused who is tried for a felony which is not barred by the statute of limitations. Swift was tried for first-degree murder, which is not barred, may not be convicted of a lesser included offense which is barred by the statute. And it cites Hickey, Turley, Hicks, and State v. Landis.
Well, I think
Right.
I think everybody agrees that principle is settled, and that is if we did not have a superseding indictment with tolling language, then, and if the jury had found Mr. Swift guilty of voluntary manslaughter, wouldn't stood, right?
Well, here's the deal, though, Judge. In this decision, it talks about how it's to be treated, and it says that at the time, and I'll say this: the decision I sent up this afternoon is a pretty recent Court of Criminal Appeals decision. In that, it was a felony with possession of intent to sell or deliver case. The defendant requested a lesser included 2 misdemeanors. The trial court, declined to give the instruction because the statute of limitation on those misdemeanors expired. This is one just like this. It's presented straight to the grand jury. The judge declined, which was his right to do. But given that instruction on something that is not actionable, as the language that the decision says, is a nullity or void, because it's not actionable at the time it's submitted to the jury.
Well, let me ask you this then. Does the mistrial
No.
return us to the exact position, not us, does it return the case to the exact position that it occupied before the trial?
If it was an offense in which was commenced properly and within the statute of limitations, yes, a mistrial would put us back like it was before. However, he was acquitted of all the ones in which the statute of limitations had not possibly expired.
So the jury never had the
They never had the right, and you had the right to not even give the instruction. And if you gave the instruction, it cannot be acted upon because it's a nullity or void. And unless the defendant waives it. And that's what some of the later decisions talk about, what that constitutes. And it has to be a knowing and voluntary waiver. The decision that I sent you this afternoon, just because it's a later decision, it talks about it when the waiver issue. It says that even though the defendant in that case submitted in writing asking for the lessers that were barred by the statute, but the judge on his own initiative said, I'm not going to give these lessers because the statute of limitations has expired. And he appealed it to the Court of Criminal Appeals. And
there's no waiver in that.
There's
case.
not.
When I read it, I'll find that they said no waiver.
That's right. And it's towards the end, Judge, if you look at it. And it says it has to be a knowing and voluntary waiver in which the defendant says, I waive my rights to the statute of limitations to have these waived. And defense counsel asked for those because he thought they were possible lessers. And one of them was. The court agreed that it would be a possible lesser. But if they're lessers and they're given, I mean, you can either decline to give them, which is what several other decisions have said, even if I request it. But the court asked, I did not submit a written request for certain offenses. The court asked about our input, and I told the court, I referred you to a book. But I didn't waive any statute of limitations, and Mr. Swift didn't. And another decision talked about a guilty plea, and that's the Pearson case, which is after Seagrove.
Now, a lot of legal analysts are actually speculating that if you were to follow the letter of the law, then actually, time is up on this one, and he very likely will walk away. But it all hinges on the judge's decision. Now, what do you think? Can David Swift walk away with these charges due to the statute of limitations? Is there a little loophole there, or is that just the letter of the law and we've got to follow it through? That's why we have this justice system. And what does it mean for the future of the Karen Swift case? Legal experts suggest there is a real possibility that Swift could avoid conviction entirely. The following is the defense and the prosecution laying out their arguments to the judge.
I guess, I got to think about it in a way I should think about it. Is what you are saying is that once the jury returned not guilty verdicts on the offenses for which the statute of limitations had not run. The case was over with.
Yes, sir.
There is no further, there's no return to pretrial indictment status. There's nothing that saves the case at that point.
That's exactly right, because
That's your
it is. And that's the language that's used by our appellate court in Seagroves and also in Pearson. But it gives the language that we have a substantial right that the statute limits, and the right creates an absolute bar to the prosecution of a criminal offense after the expiration of the period designated by the statute, which in this case, for the two most serious, well, the ones that they did the post-superseding indictment are C felonies. If you look at the statute in 2011, Judge, the statute of limitations for C felonies was 4 years. You have to use the statute in effect at the time of the offense. And basically, it deprives, in Seagroves, it said it deprives the court of subject matter jurisdiction. And it makes them not actionable. And it says here, because the period of limitations has elapsed and ceased to be a punishable offense, no court was then authorized to pronounce a sentence against the person who committed it. That's exactly what is in the decision. And so once the ones that jeopardy attached were over with by not guilties, these were not actionable. And so for that reason, and the state doesn't get to go back afterwards, after a trial, after this has occurred, and say, well, we're going to present a new indictment, a post-superseding indictment, which they could have done before. They don't get the right to do that. And there's also an issue with Rule 8, the one I filed Monday morning, that talks about this issue. And there's a decision attached to it. The Seagroves talks about it. Pearson talks about it. Now, in Seagroves, it says, which is the earlier decision, you don't have subject matter jurisdiction once the statute doesn't apply. But Pearson sort of changed it. It didn't take it away. It said the defendant's got to knowingly and voluntarily waive it. But it upheld the decision in Seagroves and the fact that the statute of limitations has got to be complied with. Jeopardy attached. These were not actionable. The state had not done anything before to amend it. The statute of limitations had expired, and so it's over with. Now, that's our position on the first one, and it carries over, I submit, to the second one. And it carries over because of, in Seagraves and in Pearson, they dismissed the conviction. I guess they had been convicted. But a mistrial when the statute, and in those, the decisions he's talking about that he cited, the state cited, the statute of limitation, there was no issue. These were indictments that were filed within the statute of limitations. There was a mistrial, and because there was a mistrial, the ones they filed for a double jeopardy violation, and the case law is clear. They can return just like they did before, but this is a different situation. And so I would just ask Your Honor to look at these and look at the case law that you may find, but it's a valid issue. And I've consulted with others about this. I know this is complicated. It's complicated for me. But at the time those lessers were given, they were expired. They were not actionable. And he did not waive it. And if he did not waive it, then
You're saying that the court could not have entered a judgment on
That's
the
right.
jury verdict, even if it returned a guilty verdict on voluntary manslaughter.
yes, sir.
Okay.
Now, if you
I
look,
understand your real late argument.
All right.
On mandatory joining. Although the case that I think relies on that for the case where it was not a lesser included offense, that's where the court made the mistake of charging a lesser that was not a lesser, and
the state went back and indicted them for
right,
it.
and that was subject to mandatory joining.
Well,
I get that.
the point of it, though, is, Judge, what the state's trying to do in this new indictment is the same exact facts, the same exact issues as the first case. It relies upon that. If you look at Rule 8,
It's the same episode.
It is.
Yeah.
And it's not continuing. It's not something brand new that they didn't know.
But I think the difference in the case you cited and the state's position is that in that case was not a lesser included offense. It was a
Well,
different offense.
It was reversed and dismissed. What I filed does apply as to Rule 8. And this new indictment should be dismissed for the reasons I stated on the first one, because of statute of limitations. And it is a double jeopardy violation if you allow, when the statute says the offense is not actionable, on voluntary manslaughter or aggravated assault or any of the ones below that, he did not waive it, and it was a nullity. And so when the jury reached their decision on the ones where the statute applied, it was over with. And if you allow the state to, which they did, get a new indictment and put him to trial again, it's double jeopardy, I submit. And I did submit some stuff about collateral estoppel. It talks about the right to have things decided at one time and then to have it all brought up. For all these reasons, we submit that obviously the first one was dismissed. We'll draft the order, but it applies to the second one. It affects the second one. And so we asked that the second one be dismissed also.
Let me hear from the state.
Thank you, sir.
Yes, sir. General, I hate to do this, but I've got to start with a question.
That's okay.
I don't mean to throw your train of thought off.
It's okay.
What about this idea that or the argument that once the jury returned a not guilty verdict as to first-degree murder, attempted first-degree murder, second-degree murder, and attempted second-degree murder, the case was over with because I could never have entered judgment on a verdict of guilty to any lesser, any below that level. I don't know about attempted second-degree murder, but certainly those aren't at issue. But voluntary manslaughter is that the case was over. There is no return to a pending indictment because everything that could be lawfully dealt with by the jury had been dealt with at that point. That's troubling me.
Yes, sir.
In terms of how to think about that.
Sure, I understand. Your Honor, I think the answer to that is that even if you had done that, even on that day, if you would have said, okay, statute of limitations has run, there was no tolling language, we still could have come back and got this same indictment because the statute of limitations has not technically run on this case. There is a statute in Tennessee Code Annotated that specifically allows that to happen.
So you don't think you had to get a superseding indictment? You could have just
I think I could have just come back
an independent, brand new
Yes, sir.
indictment
I think I could have just come back and got a new indictment.
based on the tolling.
Yes, sir. And,
Statute.
yes, sir.
Okay.
And it's Tennessee Code Annotated 42-103, and states period of concealment of crime or absence from state. No period during which the party charged conceals the fact of a crime or during which the party charged was not usually and publicly resident within the state is included in the period of limitation. And we included in the indictment that from 2014 through 2016, he did leave the state of Tennessee in 2014, which was before the statute of limitations ran. He moved from Arkansas to Louisiana to Alabama within a 2-year period from 2014 to 2016. Once he left in 2014, under this statute, we had a right to come back within a 4-year period of him moving back to Tennessee. He still is not moved back to Tennessee. He is still not a resident of Tennessee. So, we think that regardless, we could have still come back and got just a brand new indictment and started over with anything. I don't think we could have charged additional crimes, but I think we could come back with anything that we included that was a lesser included offense, but the statute had run because the language was not included. I think we could have come back with a new indictment for those charges.
Do you think the Rule 8 argument works if it were not a lesser included offense?
I'd like to argue that. I've got several cases I would like to talk about, if you would allow me
Sure.
to do that.
Yeah, I'm interested in hearing.
And Your Honor, I think this case is not as complicated as it's being made out to be. It was a mistrial. So we know that from manslaughter down, for any lessers, if there was a mistrial, we get a new trial. We start over from scratch. So that's the first thing. Second thing is there's this argument about statute of limitations that has run. It has not run. There is a statute in Tennessee that I just read you that specifically states it has not run yet. So those two arguments are pretty much moot arguments.
Well, let's look at those two arguments. If you relied solely on the first indictment, this case would have been over.
Yes.
And you fairly and candidly conceded the case is over,
Yes.
because under that first indictment,
Had he been a resident of Tennessee the entire time?
tolling had never been alleged
That's right.
in that first indictment.
Right.
All right.
Okay, Your Honor, if I could, first of all, I would like to address the case. He talked about State v. Gossett. I got that.
Gossett, yeah.
Yes, sir. I was almost late getting here because I got it right after lunch and was printing it to get over here. But I did glance at it while he was talking about it. And what he's talking about is what that case talks about is there's no waiver of statute of limitations.
You think there was a waiver in this case?
No, sir. I'm not saying that. But the difference in the case he's citing in the case today is there was never a waiver. The defendant requested those lessers, and the court didn't give it. And the court was basically saying he didn't waive that. And he didn't waive that statute of limitations because it was not specifically asked about. The difference is that there was not a superseding indictment in that case. It's a totally different argument. Our argument is about a superseding indictment. So that case doesn't even apply. Voluntary manslaughter and aggravated assault. Both of those are lesser included offenses of first-degree premeditated murder. There are numerous cases that state that. Your Honor, in State v. Johnson, the court held that they did not believe that Rule 8 was implicated in that case because the state did not attempt to allege multiple offenses. It alleged a single offense of homicide, which is what we did in this case. Also stated that the state did not attempt to allege a second offense, as would have been the case, for instance, had it attempted to allege commission of robbery as a predicate offense that was suggested in the superseding indictment. So if we had added an additional charge that was not related. So our theory of this case was that this was a murder that occurred as a result of divorce and jealousy and control and those type things. If we had come back and changed our approach in theory and said, well, we think that there was a robbery gone bad, and we put that in there, I think that would be an issue because that was not facts of the first case. And that's not what we're doing in this case. States that a Rule 8 violation is recognized when offense alleged in a succeeding indictment was based upon the same conduct described in the first indictment, but the latter charged offense was not a lesser included offense of the first. And we didn't do that. Anything that is in this indictment is a lesser included.
I understand.
State v. Hilliard also stated that it was regarding mandatory joinder of offenses as well, and it states that it did not, in that case, they said that the state was not barred from retrying the defendant on the first indictment with a second indictment, which the state filed after the first trial ended in a hung jury and added additional charge. So in that case, it stated that after a hung jury, that it was appropriate for the state to go back and get a new indictment, and they could even add a charge as long as it was a charge that fit within those facts. Your Honor, which is exactly what you asked me when I first came up here.
Right.
What would have happened, and I told you I still could have just gone back and got another indictment. Your Honor, and that's what State v. Hilliard talks about. Your Honor, in State v., I'm going to mess this up, but I think it's Volkalich. The trial court found that there was no error, that the trial court allowed the state to add counts to a superseding indictment filed after the first trial resulted in a hung jury. Your Honor, same exact issue that you had just asked me about. So I think that those are my answers to your question about Rule 8. Your Honor, as far as double jeopardy, State v. Beatty appears to be the controlling case. And It was a case that was decided in 2019, so it is a fairly recent case. It states in order for double jeopardy clause to apply, an event must occur that extinguishes the original jeopardy. A court's decision to declare a mistrial after a jury fails to reach a verdict is not one of those events. Your Honor, so that is not an event because there was a mistrial that that jeopardy attaches, and there would be double jeopardy for the
I think what
remaining
Mr.
charges.
Taylor's saying, though, and in reality, there's not even really a mistrial. The jury considered and acted upon all of the offenses that they could lawfully act on, and even though the court declared a mistrial because the jury was unable to agree, in reality, case was over with. I think that's part of the defendant's position.
Right, but which means
You're saying if that's the case, fine, I'll go get a different
get a
indictment
new indictment. Yes, sir.
rather than superseding,
Yes, sir. It would
And
just,
I don't know that it identifies itself as.
it does not. It's just an indictment. We call it
We're calling
superseding
it
because there's still an indictment pending.
Okay.
There's now no longer that indictment pending.
Okay.
It's been dismissed, so this is just an indictment now.
Okay.
In State v. Beatty, I'm sorry, I lost my spot
I
here, Judge.
keep
Let me.
interrupting you.
That's all right.
Tends to happen.
The appellate courts of the state have previously considered this issue, and it's the same issue that's been raised by the defendant in his motions today. And it's on whether a superseding indictment, or I guess what we would call an indictment now, after a mistrial on the original indictment can occur. And the answer is absolutely yes, it can. In State v. Beatty, the trial court granted a motion for a mistrial after the jury returned a verdict convicting the defendant. The state then filed a superseding indictment alleging the same offenses as the original. After considering the above cases, the court also considered, they looked at United States versus Corona, which was from the 11th Circuit. And that court stated that after a mistrial because the jury hung or for any other such reason, the defendant would have ample time to prepare his defense under a superseding indictment. And that's what we allege here. The court obviously is going to give them all the time that they need to prepare for another trial, so they will have ample time to do that. Therefore, even though jeopardy has attached to the defendant, the practical effect of a superseding indictment after a hung jury is no different from one returned with ample time before a trial on the merits. So whether it was a superseding indictment or a new indictment, the defense has more than enough time to prepare for the case. The court also stated that the state did not file the superseding indictment to harass or intimidate the defendant. Also, that the appellant had plenty of advance notice of the charges against him, and the additional language in the superseding indictment did not change the substance of the original indictment. And that is the same thing that we're arguing here. This language does not change the substance of the original indictment. Still the same substance. The only difference was the tolling language. In our case, we did not file the indictment to harass or intimidate the defendant, Your Honor. And as a matter of fact, one of the reasons, in addition to the tolling language, that we felt like we needed to do a new indictment was to clean it up. Because if we go back for a second trial, I'm required to read the indictment to the jury. The only thing I would have been able to read to them is premeditated first-degree murder. And then there would be confusion about, wait a minute, I thought we were here for voluntary manslaughter. So it was also to clean up the indictment so that we could read the correct charges that we were attempting to prosecute to the jury. Your Honor, as far as collateral estoppel, the 11th Circuit also dealt with that issue in Schenberg. And the court said that there are two steps that the court must inquire about for collateral estoppel before it will apply. The first is that the court must examine the verdict and the record to see what facts, if any, were necessarily determined in the acquittal at the first trial. And second, the court must determine whether the previously determined facts constituted an essential element of the mistried count. Your Honor, in this case, the defendant was acquitted of premeditated first-degree murder, second-degree murder, also the attempts for both of those. And Your Honor, for those, for first degree premeditated murder, you know that it's premeditated and intentional killing of another. For second degree, it's a knowing killing of another. For voluntary manslaughter, it's the intentional or knowing killing of another in a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. And then we also indicted aggravated assault, which is the intentional knowing or recklessly causing serious bodily injury to another. Your Honor, we would also assert that there are additional elements required for voluntary manslaughter that are not required for first and second degree murder. Your Honor, specifically talking about the provocation in the case. And Your Honor, because of that, the doctrine of collateral estoppel does not apply. It should not bar the defense of the state.
Do you think that makes voluntary manslaughter not a lesser included of premeditated first
No,
degree
sir.
murder?
The state, the courts have held on numerous cases that voluntary manslaughter is.
Well, I charge it as a lesser, but I just,
Yes, sir. And there are cases that, and I can give you those that do say that it is a lesser included offense.
Okay. Anything else?
No, sir. Thank you. All right. Thank you.
Mr. Taylor, you want a chance to just finish us out briefly?
In 4 years, but that doesn't end. And they chose to indict for whatever offense. I point out the lesser alternative counts that are sometimes given in this court and other jurisdictions I go to. They could have chose to do that. They did not do that. If they chose to do that and they had added the offense of voluntary manslaughter and aggravated assault, what would be required would be to put tolling language or commencement language in there like what they're trying to do now. Now, if they had done that pre-trial, before the jury was sworn, before the proof started, then we'd be in a different situation. That wasn't done. For whatever reason, they didn't do that. They don't have to do it. They can do it. If what they're trying to do is, now they say they should have done it then. But at the time the jury considered it, it was not actionable. And even if the jury convicted him, it could be set aside. But just because there's a mistrial, but he did not waive any issue, and the statute of limitations was expired. And now to allow the state to say that, well, we can go back and add commencing and tolling language after the fact does create a double jeopardy issue, because these are charges that they're related. They're all the same incident, but they're offenses which they could have added before. And that's why I cited the statute of limitations issue and the Rule 8 issue. Now, regarding Rule 8, they said in that case I cited to you, and yes, it was a different offense. It wasn't a proper lesser, but I submit, Judge, you shouldn't dismiss it because of that, because the state went back afterwards and tried to add a different offense than what he was indicted for, just like in Swift. He wasn't indicted for aggravated assault. He wasn't indicted for manslaughter. And the court said that Rule 8 bars that, and it said it was part of the same criminal episode after the conclusion of the initial trial. And basically it says subsequent indictments were permissible after the defendant was tried on an initial charge if subsequent charge was not known. Now, that's not the situation, like if something wasn't known. They knew all this when they had the first indictment.
He's conceded that.
And so, or if a second court had jurisdiction, you're still the same court. You're not a second court. And it said that the subsequent indictment was prohibited because the state was made aware of the facts that gave rise to the charge, the new charge that they're trying to do, just like here, when they initially charged him with first-degree murder, because it was a basis for the felonious assault charge. And basically, it's the same situation as Swift. It's the same basis, the same facts. And it knew of this, and now they're trying to do this, and it's a violation of Rule 8. Court said other things, too. And they said that there's no evil results from subsequent indictments before trial They say that that's good. That's allowed. There's no question about that. But this is a different situation. But with additional offenses that are based on the same conduct, which arise from the same criminal episode upon which the prior indictment had been returned, he had been tried on it, though. And they say that that's allowed when he's not been tried. But he has been tried. As previously noted, the purpose of Rule 8 is to prevent multiple trials on charges arising from the same conduct under the same circumstances. And it goes on to talk about it in another decision that I have, State v. Blair, which is the Court of Criminal Appeals, July the 9th, 2015, March 24th, 2015. It talks about, and it doesn't require bad faith on the part of the state. It just basically says they selected the indictment that it wished to prosecute at trial. That's what it says in this decision. At Swift, they selected the charge which they wished to proceed at trial. The prosecutor and the state chose to proceed on that charge. Now, after a partial acquittal, which is what we have here, I submit that it's a full acquittal, though, because the statute of limitations issue, they weren't actionable, and I'm not going to say that over again, Judge. But the state's attempting to prosecute the defendant on a charge that it deliberately declined to prosecute in the first trial. They just didn't do it. And they didn't put commencing language. And I just think I think it's a misstatement of the statute to say that you don't have to put commencing facts or tolling language in. And it's a requirement. The jury heard all this, and they didn't hear any proof about commencing concealing facts or tolling language in the proof. And so it should be dismissed with prejudice. But it declined to prosecute in the first trial these charges. The effect would be to subject the defendant to a separate criminal trial for multiple offenses. These are two offenses he wasn't charged with in the first one, so that does apply. He wasn't charged with these. You gave him as lessers, but that were mandatorily consolidated expressly prohibits. We conclude that the trial court properly found Rule 8 precludes prosecution on these other charges. So I would submit that to you, Judge. That's where I stand.
Okay.
You have any questions?
No, sir. Thank you. Both of you have answered the question.
Yeah, could I respond just real briefly to Rule 8? I promise it's brief.
Okay. I take it at your word.
Yes, it is.
You know, he talks about Rule 8, that it prevents us from being able to go forward because he's saying that we added additional charges. State v. Johnson, which I had cited earlier, states that a Rule 8 violation is recognized when an offense alleged in succeeding indictment was based upon the same conduct, which it was, described in the first indictment, but the latter charged offense was not a lesser included offense of the offense charged in the first indictment. It's not the case here. It is lesser included offense. It's not a violation of Rule 8.
And in all the cases he cited, Judge, the statute of limitations was not even an issue. That makes a difference.
I'm arguing against Rule 8. I don't know if he wants me to argue against Rule 8 or statute of limitations.
I got it. I understand, and I appreciate what you all told me. My goal today was to ask you for some law, and asking you shall receive, evidently, because you all have bombarded me with good helpful resources to help me decide it. I need to think about it some, and I want to take enough time to carefully look at the cases and the arguments. I've taken notes about the positions that you hold, as well as the concessions that you've made to try to narrow this down to the realistic. What the realistic issues are in this thing. I think probably the best thing we need to do at this point, go ahead and set an appearance date.
Yes, sir.
There. In the meantime, I will have you, I'll prepare and enter an order. You're going to do an order on the dismissal of the original indictment. Mr. Taylor, if you'll do that, get Mr. Goodman's approval, and then email that to me.